Never mind.
Sure, I need her to give me proof, because I looked it up and it says he's not in custody anymore.
Okay.
But I don't know.
The bondsman said that Mr. Spencer may be in federal custody. And so if he is, then I will go ahead and make it, I'll change that bond forfeiture to an at-large without proper bond, leave the bonds at $100,000 on each either way. But I would make it at-large, but we're going to get that confirmed before I make that change.
Okay, and I'll check.
Okay, thank you. Mr. Macon, I'm ready on Bethany Loza Diaz plea. Good morning. Are you Bethany Loza Diaz? Speak up, please.
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Loza Diaz, in cause number 25, DCCR 0928, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 4th of 2024. And how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon? Do you fully understand them?
Yeah.
Is there something you don't understand?
No.
Do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And so it looks like the agreement that you reached is for 2 years in the state jail prison, but instead of serving 2 years in the prison, you would be, that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding of your agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objections, Your Honor.
It's admitted. Is there any evidence that Ms. Loza Diaz is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there, okay? All right, we'll see y'all back at sentencing. Let's see, Ms. Norman on Charles Gry Jr. Good morning. Are you Charles Gry Jr.?
Yes, ma'am.
And Ms. Norman, will your client waive the formal reading of the indictment?
He will.
Mr. Guidry, in cause number 23-41646, you're charged with the state jail felony offense of theft and aggregation amounts from January 1st of 2022, continuing through June 30th of 2022. And how do you plead to that charge? Are you pleading?
Right here, notice how smoothly this plea is going, but the real twist comes when restitution enters the picture. Restitution can completely change a defendant's future, especially when the amount is this high.
Guilty freely and voluntarily. And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Norman? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to pay restitution, and that amount, I guess, needs to be determined.
No, well, actually, Judge, I have an amount here. That amount would be $6,136.
And Ms. Norman, are you prepared to agree to that today? I could waive the pre-sentence report, or do you need some time to review that?
No, we're prepared to agree to it, Your Honor.
So you understand also as part of your agreement that you would pay restitution in the amount of $6,136. Is that also your understanding?
$6,136 may not sound huge to some people, but in probation cases, unpaid restitution is one of the top reasons folks get revoked. Judges take repayment very seriously. This is basically the defendant's tightrope.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Guidry is not competent?
No.
And Mr. Lewis, since we have that restitution amount, any reason not to go forward with sentencing?
No, Judge, but in full candor with the court, I just want to let the court know that this defendant does have criminal history.
Okay.
However, Ms. Norman made a compelling argument about the restitution being paid under the terms of this agreement, and that's why I'm entering into it. I'm happy to explain or go into more detail about the community if you like, but
As long as you're comfortable, and I think I'm good with that. So what I'm going to do, Mr. Guidry, is find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, waive the pre-sentence report, follow the agreement, find you guilty of state jail felony offensive theft, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. I'm going to follow the agreement and probate that for 5 years. You are ordered to pay a $500 fine, and you're ordered to pay restitution in the amount of $6,136, and to follow all of the other rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over. You'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you would be facing that 2-year sentence that you've already agreed to. Do you understand? $6,000 is a lot of money. Some people think, I've got 5 years to pay it. I want to make sure you understand. I want you to start making payments on that immediately. Even if it's a little bit every month, it'll add up. Some people think, well, I'll wait till my tax refund next year, or I'm going to sell something. So make sure you make payments regularly, because what can happen is you can do everything else you're supposed to on probation correctly. And at the end of the probation, if you haven't paid that restitution and I make a finding that you could have paid it, you could still be revoked after 5 years and go to prison. So it's very important that get paid back, okay? I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written document to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Norman. All right, if you'll just have a seat here in the courtroom, probation will get your paperwork together. She's at that desk right there. She'll call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
This is the moment everyone forgets. Even after the sentence, probation paperwork is where reality sets in. Rules, fees, check-ins. It's the fine print that can make or break whether someone actually succeeds on probation.
Mr. Parker, you've got James Bruno. It's a sentencing. Good morning, sir. You're James Bruno. And this is 24 DCCR 1151. Mr. Bruno was previously in court, entered a plea of guilty to evading arrest or detention with a motor vehicle. I have received that pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections? Mr. Bruno, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would become a convicted felon, and you could be sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. Do you understand?